Tampering with a government record. What is it? What kind of crime is this? What does the government have to prove in order to sustain a conviction? Hi, I'm Jeff Hampton with the Fulgham Law Firm. I want to thank you for joining us on our YouTube channel today. Today I'm going to talk about the crime of tampering with a government record. It seems like it's pretty self-explanatory, right? Some type of government record and you messed with it. Well, there's some layers to it and we're going to break it down for you just to give a little bit better understanding of the crime. And by the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, now let's jump into this. And when you're going to look into the crime of tampering with a government record, you have to go to Texas Penal Code section 37.10. And under Texas Penal Code, under that provision, the following elements of tampering with a government record must be proven beyond a reasonable doubt. A person commits an offense if he knowingly, pay attention to all the criminal mind elements to this. It has to be something you did knowingly. Makes a false entry in or false alteration of a government record. Makes, presents, or uses any record, document, or thing with knowledge of its falsity and with intent that it will be taken as a genuine government record. Intentionally destroys, conceals, removes, or otherwise impairs the verity, legibility, or availability of a government record. Possesses, sells, or offers to sell a government record or blank governmental record with the intent that it be used unlawfully, or makes, presents, or uses a governmental record with knowledge of its falsity, or does it with the intent, with the intent for it to be used unlawfully. Now, look, there's a lot there to go through. It gives you like 5 different ways that you can commit the crime. So let's talk first. This gives you a better understanding of what we're actually doing here when we first break down the range of punishment. Based upon each of these options of ways that you can commit this crime, the state of Texas has given levels of punishment to where they think certain ones are more serious than another. So normally tampering with a government record is classified as a Class A misdemeanor, punishable by up to 1 year in the county jail and up to a $4,000 fine. However, if the state of Texas alleges that you acted with the intent to defraud or harm another person, you may be charged with a state jail felony, punishable by for a minimum of 180 days, up to 2 years in a state jail facility, and up to a $10,000 fine. Now that we're working our way up, we started with a Class A misdemeanor, we went to a state jail felony. If it's being used with the intent to harm or defraud another, you can then be charged with a 3rd-degree felony if it's proven that the government record was one of the following: a public school record report or an assessment instrument required under Chapter 39 Education Code, or was a license, certificate, permit, seal, title, letter or patent, or similar document issued by the government or the United States, unless the actor's intent is to defraud or harm another. So let's break this down. If you use one of those elements that I just talked about, one of those government records, that makes it a 3rd-degree felony, punishable by up to 10 years in prison and up to a $10,000 fine. However, if you use one of those same documents and you use it with the intent to harm or defraud another, that can now elevate it to a felony of the 2nd degree, punishable by a minimum of 2, up to 20 years in prison, and up to a $10,000 fine. And so in that situation, it becomes a much more serious situation. Obviously, the legislature is looking to punish people more severely if that document was tampered with in any way with the intent to hurt someone, right? Or defraud someone in any way. So the other little small section here is that if you present a standard proof of motor vehicle liability insurance form and that form is proven to have not been issued by the governmental agency, that is actually a Class B misdemeanor, punishable by up to 180 days in jail and up to a $2,000 fine. So I tell you this because there are people out there trying to sell you like a free, like a fake inspection sticker, or they're trying to sell you like a fake motor vehicle registration and all that sort of stuff. If you have one of those and you go to get your registration renewed and they find out you have it, you can actually be arrested for it. Okay, so that's one of the examples that we talk about. We've actually represented people in exactly that same situation. So look, it's a serious enough charge that you could be facing either a misdemeanor with jail time or up to a very serious felony charge with up to 20 years in prison. So one of the most important things to do is to get an idea of understanding some of your legal defenses. So our first legal defense is a lack of criminal intent. Remember, a person commits an offense if he knowingly makes a false entry. I'm going to just go through some of these. With knowledge of its falsity and with intent, or intentionally destroys, conceals, or removes, or acts with intent that that government document be used unlawfully, or that you use it with knowledge of its falsity, or with knowledge that it was obtained unlawfully. Now, I skipped through all of those. What were they? 1, 2, 3, 4, 5, 6 ways that you can commit the crime. But each way that's listed under the code has knowledge of, with intent to use. Every one of those has some specific intent knowledge that shows you had to have known what you were doing. You had to have had fully invested in knowing that this was a scheme or plan for what you were doing in that situation. So you must either know of its falsity or you must have knowledge that it was obtained unlawfully. So one of the most classic examples we see of this is we've represented clients that a friend came to them, or we've seen this, God forbid, happen even with homeless folks, people that are out there down on their luck, where some guy pulled up in a van saying, hey, listen, if you'll go in there and present this check, or you'll go in there and need assistance with my government check, if you'll do this, or if you'll change this or sign it for me, if you do this or that, they'll come in and with all these different things telling them that what if that client had no knowledge that it had been tampered with? And this is the most classic example. They don't know that it's a false document. They have no idea, but yet they go in and they present it and they had no knowledge of its falsity. If someone else gave that to them to go do it, the original person should have been the one that got arrested for it, not the poor guy who had no idea that it was false or that it had been tampered with. The state of Texas must be able to prove that you had knowledge of its falsity or that you were the one that had tampered with it with the intent to do so, okay? So in that situation, because it was the burden of the prosecutor to prove that case beyond a reasonable doubt, we were able to show some evidence to the grand jury. And remember, in a situation where, of course, the police and the DA were trying to claim that that was being done with the intent to harm or defraud another person, if it is a felony charge, that felony charge can be presented to a grand jury, and a grand jury can make the decision to possibly no-bill the case, throw the entire thing out because the mental state element of the crime was unable to be proven, okay? So that's one of the things to be aware of. What if the burden of proof is just not able to be met by the state of Texas? And here's the thing, one of the most common basic tenets of our Constitution is that you have a right to a jury trial. You do not have to prove anything, but the state of Texas must always prove every element of the crime beyond a reasonable doubt. And so every single doubt that can be established or holes that can be poked into the state's case provides you and your criminal defense attorney leverage to negotiate a more favorable result. Every single time someone comes to hire us for a crime, they have the same goals for the most part. They don't want to go to jail. They don't want to go to prison or go to jail. They do not want to be a convicted felon or have a conviction of any sort whatsoever. And then number 3, they want to resolve the case in somewhere where they can get it off their record, particularly if they are a first-time offender. These goals are important to be able to achieve, but you have the best chance of achieving those goals if you're working with the right attorney very early in the criminal case process, okay? Now listen, I hope this has been some of assistance to you. This offense of tampering with a government record is a little confusing. There are many different ways that the state claims it can be proven. So if you or a loved one are facing this type of charge in the North Texas area, we want to offer you a free case analysis and consultation. You see this number that's been up on the screen the entire time I've been talking. Don't hesitate to give that number a call. We'll schedule you for a free case analysis and consultation. And I promised you a free ebook. You waited around to the end of this video, click through down to the bottom of the screen. You'll see in the notes section of YouTube, we will send you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. By the way, if you liked what you heard today, subscribe to our channel, like this video. We'll send you more great content just like this. Thank you for joining us here today. We'll see you next time on our next video.